So, Anne, can you see the slide?
Yeah, you're all set.
All right, excellent. So first of all, thank you, Anne, for that introduction. And I have indeed spent a lot of years, more than I care to think about, in corporate America. But for the past 3.5 years, as Anne mentioned, I have been trying to help survivors of sexual misconduct be able to tell their stories. And they come to tell me their stories because they've not been able to tell them to the leadership of the communities where the abuse has been taking place. Sometimes they can't do that because of unspoken norms, like, for example, that the teacher is considered infallible as a doctrinal matter, or the teacher is just so powerful personally that it is not possible to imagine bringing a criticism to the community. Sometimes people don't speak because they see what happens to other people when they do speak, that they are ostracized, they are excommunicated. And so they have sometimes told someone in a high level position, this happens all the time, who says, you know what, maybe you just don't want to say anything about that. Maybe it's not worth it. And so having not found justice within their own communities, they begin to look for justice outside of the community. And that often means an ability to at least tell their story and have that story be listened to. But the next step in that, and this is something that I think a lot about, and that I think that we're going to see more and more of, the next step on the journey to justice for a lot of these people is into a court of law. Because there has been no recourse for them within their communities. So that's what I want to talk about today. Why am I here? I'm here because I know a very surprising fact, and that is that much of corporate America is doing a better job of these kinds of sexual misconduct and sexual abuse issues than spiritual America is doing. It would have been impossible for me to have kind of considered that as a possibility 3.5 years ago, but it is. And it isn't the case because sexual misconduct doesn't happen in corporate America. It does. Of course it does. It's not because they're more moral or they're more ethical than spiritual communities. It's not that. It's because they understand the law and they understand very, very clearly the consequences of failing to follow it. And so over the last, I would say, since about 1996, so what is that, 20 some years, they have built robust models, a particularly robust model of prevention and cure for these issues. So I am here because I know that there are spiritual communities out there that want to do the right thing, but don't know how. I hope that that's why you're here, because the right thing is ensuring that sexual misconduct doesn't happen to begin with. But as importantly, and I think a part that's often overlooked, is that you need to respond to it in a way that the law requires, which is designed to ensure that it doesn't happen again. So my job in our next hour, or just probably a little bit more than an hour, because we'll take questions throughout, my job is to try to distill that law down into something that you can take away from here today and take back and apply to your Sangha. And your job is to engage and to ask questions. So Amy's given you the information about how to ask questions in Slido, and I encourage you to go to that app. Questions are so important. They're important for all of us. It's particularly important for me to understand kind of what you need to know and what you are not understanding. And for all of us on the call and for those people who will listen to the call later. So I really encourage you to do that. We're going to stop along the way and make sure that we take some questions so that we're getting some understanding and some feedback as we go. So what are we going to talk about today? First of all, I want to kind of get us all on the same page with some definitions about the types of sexual misconduct and also of negligence. Then I want to just give you that kind of 3-step robust model to avoiding these kinds of problems in the workplace. It's pretty simple, but it's not easy to do. So we're going to talk about it a bit. And then I want to give you some nuts and bolts of things that you should have in what that robust model is, which is a policy, a process for reporting, how to do an investigation, and then to take action. So this is squeezing a lot of what is sometimes dense legal information into a short period of time. But my hope is that we can at least build an awareness that there is information out there that could help us with these things, and that it can lay a foundation for you to be able to assess what you have in place within your own communities now. So, questions. Again, I want to see questions, and I see one already in Slido, and Anne is going to help me with this, because I hope that we're going to just be deluged with questions. We're not going to be able to answer them all, but I think that Anne and I are going to make sure that any question that is asked gets an answer, which we will then send out in a follow-up. So questions, if you have any problems getting into Slido, I think you can probably chat or let Amy or Anne know. So let's get started. Sexual misconduct and legal liability issues in the Sangha. Number one, I am primarily talking about the law in the United States, although it's conceptually very similar in Canada and probably in the UK as well. So as a model, which is what I'm going to give you, it should work no matter what kind of jurisdiction that you're in. So there is potential liability for the following kinds of things, and we've seen all of them lately in a variety of communities. But the first one is sexual assault. So the problem with sexual assault is that you have to think about this without the word consent, because this is very confusing. We'll talk a bit about consent in a moment, but basically when you are talking about, if you are talking about a teacher or a leader being involved in a sexual assault or a touching of any kind, then consent really does become very slippery. So we want to kind of take that aside for now. In 14 states, actually not 14 states, but in 13 states and the District of Columbia, these states have laws which said that if you are assaulted by a clergy person, a spiritual advisor, a teacher, that it is, the consent is not even an issue. It's not a defense. And so you'll want to look at that to see if you are in one of those states. And when we do the follow-up, I will give you, actually, if somebody will ask the question about those states, that's the best way to get it in. Ask me what states that this applies to, and then when Ann and I do the follow-up, I'll give you the list of the states in the District of Columbia in which this is the case. So you can see that in a number of places, there's already a recognition that consent cannot be possible in certain kinds of situations, and that's one of them. We're also going to talk about legal liability for sexual harassment in the workplace. And you may be saying, well, I don't have any employees, so why would this apply to me? So here's what I have to say about that. You may have volunteers, and the wage and hour laws in every state are different. And in some states, depending on what your volunteer is doing and how long they're doing it for, they may not be a volunteer. They may be an employee. So that's one reason to look at this. But the more important reason to think about the model for dealing with sexual harassment in the workplace is because it's like a best practice. It's like being inoculated. It's like setting yourself up to succeed rather than to fail. And if you follow it, regardless of whether we're talking about employees or whether we're talking about just members of your organization, you are much less likely to get into any kind of legal liability issues. And we're going to also talk about negligence. So this is very important for those of you who are on boards of directors and or maybe senior teachers in decision-making positions, because this is the kind of claim in a lawsuit that applies beyond the person who is the aggressor. So for example, in talking about liability, who can be liable? Well, certainly a person who sexually assaults someone is going to be liable. And they might be liable under both criminal and civil law. So criminal law, just to give the kind of baseline here, means if you're guilty, maybe you go to jail, or at least there's some similar kind of consequence. Civil law is different. Civil law is money only. And given that we have abysmal numbers in the United States of rape and sexual assault cases that are actually brought to trial, then civil liability has become and is becoming a greater tool for people who are seeking justice. When the criminal avenue for justice is not available, because these are decisions that are made by districts of attorneys and grand juries, and there are very, very few cases that are actually brought. When that's the case, then people turn to the civil courts for justice. And in a civil court, there can be a claim for negligence. And that is possible civil liability for a board, for decision makers, and possibly senior teachers. So in the last panel discussion, if you were there, you may remember that I referenced a case that is in fact pending in California, and it is exactly this. It is a case against, it is in civil court against the aggressor, and it includes negligence and other claims against the board of directors. So that's, I think, a good reason why we're all here is obviously we have failed many survivors. And if you're a survivor and you're here or you're listening to this, I want you to know, as we go through this law, that the law stands in support of people being able to be either in the workplace or in a spiritual organization without being assaulted or harassed. And so I want you to know also what your rights are. So let's look at the definitions: sexual assault, sexual harassment, consent, and negligence. So here's sexual assault. Contact that occurs without explicit consent. That's an interesting way of putting it. We can't imagine consent. We can't assume consent. It can be attempted rape. It can be touching, unwanted sexual touching, forcing a victim to perform sexual acts such as oral sex, or penetrating the perpetrator's body. Now, the thing that I think is important to know here is that rape comes under the umbrella term of a sexual assault. I often get a lot of questions from people who say, well, why did this investigations say that the aggressor was guilty of sexual assault, why didn't they say rape? Because maybe it was more than just rape. Maybe there were a variety of things involved, and sexual assault is the umbrella term that includes rape. Now, let's think about consent for a second as it applies to rape, for example, and sexual assault. Obviously, when adults engage in a sexual relationship willingly and with consent, the term sexual assault isn't appropriate. It doesn't apply. However, there are limitations that the law has applied to the issue of willingness, and these depend on the law of the jurisdiction, whether it's the state that you're in or the country that you're in. So if you look at the first one on my list, that consent must be established and reestablished. Silence, passivity, and ambiguous conduct do not establish consent. So this isn't in every jurisdiction, but it is in some jurisdictions. The same thing about voluntary agreement. But a voluntary agreement might not apply if the person who's being encouraged to engage in the activity it has a misunderstanding, whether maybe it's an abuse of a position of trust. So the third one down there mentions that this relationship of trust with the victim, it's the same as a manager in the workplace. For those of you who are in a workplace where you've done sexual harassment training, what seems like probably 100 times, whether it's a teacher, a spiritual advisor, when there is a power imbalance, there is a real question about whether consent can be freely given. So if, and I hope that this never happens for you, but if you are ever in your community in a situation where someone says, well, that was consensual, I hope that you will pause and say, well, yes, but is it really possible that consent was given? All right, sexual harassment. So this is the kind of thing that is oftentimes a lower level of sexual misconduct. It could be, for example, hostile environment is really hostile in the environment. Those two words together are really what we're talking about with a hostile environment. But with the word hostile, what the law doesn't necessarily mean what you might think hostile means. What the law means is that it is offensive to someone. And in the case of sex, it is offensive to someone based on their sex. And so if we're talking about crude jokes, if we're talking about sexualized language, if we're talking about sexual advances, we could also be talking about inappropriate touching that is offensive to the reasonable person. And then beyond that, we have what is known as quid pro quo harassment, which is quid pro quo, my Latin may escape me here, but wait a second, this for that. And so when we're talking about it, we're talking about in the workplace, we're talking about job for sex. So you can see two examples that I put up here. Have sex with me or bad things will happen to you, or alternatively, have sex with me and good things will happen to you. Now, I personally think that very few people are saying this kind of thing these days, but I have heard, and I've been involved in cases where, for example, there has been the concept that that a teacher may say to a student, to put it simply, if you have sex with me, it will help you along your path to enlightenment. And so I don't know, I haven't seen a court that has actually taken this up, but it sounds a lot to me like a kind of quid pro quo situation. In any case, I would not want to be presenting it to an American jury. Now, negligence. What is negligence? And those of you, again, who are in communities and on boards, then this is an important definition for you. When you have a duty of care, which is a legal responsibility to avoid harm to others. And so you probably have a duty of care in your position or a board's position within a community. When you have that and you do something or you fail to do something, which causes another person predictable damage, injury, or loss as a result. So this is like, it has to be predictable. So it's not like, oh, wow, the first time this happens, we don't know about it. We couldn't have predicted it. But the second time it happens, it's predictable, which is why it is so important that you think about the model that I'm going to give you in just a few moments. So one final thing about the law, it's very elastic. And we've seen something related to that just this past week. If you see in the news something like R. Kelly was convicted of some sexual abuse and some sexual abuse of minors, which, by the way, with minors, there is no issue of consent. There's no consent that's possible to be given. But if you saw that on the news, you may have seen that some of the claims were related to what is called RICO. And so it's an example of how elastic the law is. RICO is the Racketeering, Influenced, and Corrupt Organizations Act. It was passed to deal with mafia-type business organizations. But the law doesn't really care in a certain way. It's neutral in a lot of ways. And so if it applies, and apparently this jury thought it applied, then the Racketeering, Influence, and Corrupt Organizations Act can be used to try to convict R. Kelly. Now, that was criminal charges. Harvey Weinstein, similarly, in his court case in New York, he's one of the claims that has survived is of sex trafficking. So I was pretty surprised myself when I saw that, because what I thought was, I knew he did a lot of, things that we could all agree are pretty horrible. But in my kind of layman's idea of what sex trafficking is, I didn't expect that. But in fact, the New York statute on sex trafficking is quite broad. And at least one judge felt that it could be applied to him. I have heard words in the last year that may also rise up and become claims: soul murder, faith rape. That is the abuse of power in between a student and a teacher, a clergy person and a parishioner in a spiritual organization. So while I'm focused today on things that we're very, very clear about, that would be sexual assault, harassment, negligence. I want you also to be clear that this area of the law is moving now and will continue to move for exactly the reasons that I told you before, which is when people cannot find justice in one avenue, on one road, then they take another path. And I think that we have already seen a few lawsuits in this arena, and I can imagine that we will begin to see more. All right, Anne, how about some questions about what we've done so far?
Yeah, well, we've got a lot of different questions, so I'll try and keep to what you've covered already, but I might exceed that.
Okay.
Okay, and there's a lot of
That's okay.
questions. Thanks. So one question is, how does survivors wish for anonymity work when taking such cases through legal recourse?
Yeah.
So is it possible to maintain anonymity and, pursue legal recourse?
Yes. Great question, because of course, for many survivors, that anonymity and the confidentiality is absolutely critical to their ability to come forward, often because of the way that things have been dealt with in the spiritual community where they were abused. So the answer is yes. In legal cases, a plaintiff, that is the person bringing the claim, can be designated as a Jane Doe. So that means that for the purposes of the lawsuit, which is a public document, by the way, that people will not know that person's name. So that should not be a deterrent to people thinking about at least taking that avenue.
That's really great to hear. So this question actually is, you were talking about the definitions,
Yes.
getting clear on the definitions. So the question is, what about the legal status of rape by deception?
Hmm.
Do teachers telling students that having sex with them will speed their enlightenment would that count as rape by deception?
Yeah. Okay. So that's another that really is an example of how the law is moving and is elastic, because I don't know when that became an actual thing legally, but my guess is that it hasn't been a long time. So rape by deception. So first I have to give my kind of lawyer caveat. I cannot give you a legal opinion on this. I should have said this in the beginning, that none of this is a legal opinion, because in truth, a legal opinion goes like this. You come to me, you ask me a question, I do a lot of hours of research, then I write a paper, then I give you the paper, and then I send you a bill. So without all of that in place, I can only give you my kind of non-legal opinion, which is yes, I think that rape by deception does fit exactly that description, that example that I gave. Now, whether a jury, will buy that, whether a particular jurisdiction will allow that, I think we're going to know more about that in the future.
Great. Okay, well, another question. A major problem is that no Buddhist judiciary
Yeah.
can investigate allegations independently of the organization in which the allegations misconduct occurs. Any comment on this situation?
So, Anne, tell me, or maybe the person, well, I'll ask you first. Tell me what that means. So, for example, we all know Shambhala because they were in the news. This is public information. So they were investigated twice, once by me and once by an investigator that they retained. So tell me what you think that this person means when they say this.
I'm actually assuming they mean that an outside Buddhist organization, a kind of centralized authority, can't investigate, but I'm not sure. So the question's from Wacko, so perhaps Wacko can type in the question and maybe explain if I might not have it right.
Or an example, and then we can come back to it. And if we don't get back to it, we'll leave it on our list of unanswered questions and be sure to do it in our follow-up.
Okay, that sounds great.
Okay.
Is it okay to take another?
Yes, I was going to say, let's take another.
Okay, so this is a question about restorative justice.
Yeah.
Could you speak about using restorative justice understandings and procedures in a legal context, as well as in Buddhist communities, if you've come, into contact with that?
So I think the reality is that I'm probably not well versed enough in reparative justice, restorative justice systems to be able to comment on it. But what I do see, for example, and I'll try to talk about this when I get there, which is what to do at the end of an investigation when you have found that there's been misconduct. My experience, and this is really only my experience, so you have to understand that to a lawyer, every path has a legal conclusion. So you have to take what I am saying with a grain of salt. But to me, you need to find out first what happened, and then think about what makes the most sense for repair. So that I think that we have to have a good idea of what the abuse of power has been before we can engage in restorative justice processes. But I think that there are some parts of the legal system that are beginning to adopt that. I think it makes a lot of sense. And I do think that in communities, particularly after some time has passed and people are able to, some of the emotions have died down, that it is possible to engage in that. And I think that it would definitely make sense.
Yeah. Oh, great. I'm hearing, yeah, that would be, something after the, more kind of criminal investigative aspects have been
Yes,
implemented.
right.
Uh,
Yes, because you really do need to know what you're dealing with. From a legal perspective, it's not important so much from a legal perspective what you do as much as it is that you take prompt, and the word is effective action. And for the law, effective means designed to stop the abuse from happening again. And so if that's restorative justice, it should be fine.
Great, thank you. So I'm seeing there's a kind of cluster of questions around board liability that we might want to wait for the next break. But there's a general question about consent, which is when you say consent cannot be possible in certain situations, and there's a question about whether it can be freely given, how do we discern, like, I guess, how do we know? How can we find out about those certain situations?
Yes, well, so first of all, if you go to, and I think that Amy already put this in the chat box, if you go to RAIN, they have a wonderfully resourceful website. I use it myself all the time. And it will tell you what state you're in. If you go to what state you're in, they will give you some, a little glimpse into the laws of those states. So the really easy ones on consent are minors, people who are incapacitated, people who are asleep, people who do not have capacity to give consent because of potential disabilities. So those are some easy ones. The harder ones are situations of power. And if you, I'll give a website in our follow-up where where you can go and find out if you are one of the states in which you cannot give consent. I know that Florida is one of those states. For example, I know that Texas is one of those states. So as an example, if you are in Texas or in Florida and you have a leader, a teacher, a spiritual advisor who is having a sexual relationship with another person, who is a student, a parishioner, those kinds of things, consent is not a defense. It may not ever come up, but I can tell you that if that person who is in the relationship feels that they were raped by deception, for example, or if they now believe that they were told that this was going to increase their chances of enlightenment in this lifetime and they no longer believe that, then when you go to court saying as the defendant that this was a consensual relationship, you don't get the opportunity to say that. So if you're in one of those states, you kind of need to know that.
Great. Well, I'll just clarify the question that was a little unclear.
Yes.
So to explain further, other religious organizations have independent but internal committees to investigate allegations and impose penalties on offenders.
Yes.
But that's not
That's
the case in Buddhism.
Yes. Right. Exactly. And that is an issue, and that's somewhat of a problem, I would imagine. What I would say is, as a community, as your own community, that you may not be able to impact what's being done in another community, but you can certainly follow this model that I'm going to give you within your own community without that external kind of judiciary.
Oh, brilliant. I think that's super helpful to know. And, you know, I will add as well that, you know, in the case of the allegations made against Noah Levine, he was investigated both by his own Sangha and also by Spirit Rock, which was his wider, you know, network. And he basically, you know, refused to accept both of their findings. So perhaps you know, that's also limiting a wider network. It's only as powerful as people following it.
Well, that's right.
So it's good to know that there's still, you know, your path can still be pursued independently.
And it should be, I want to say, you know, because the independent body may have a limited ability, even if it exists, to do something about all they may be able to do, as Spirit Rock was able to do, is to say, you're not going to teach here. But your own community can follow this model.
Great. I'll just ask one quick one, because it's also about how do we define what is harassment or assault? So the question is, what about things like hugs or non-sexual touching? Would that be considered harassment?
Oh, this is a very difficult question. You know, when I've gone into a lot of workplaces where I felt like I was the Grinch that stole Christmas, you know, like trying to make everyone walk around, you know, without touching anyone. So I don't feel that way. Honestly, I've actually never seen a lawsuit that was based on hugs and based on hugs alone. And so what I would say is this, that if someone is uncomfortable hugging, you know, I've noticed that lately, and this wasn't the case probably 10 years ago, but lately, you know, people say, can I hug you? And if the person says no, then don't do it. If the person says yes, then do it. But I always used to say in training, get in, get out. Don't linger there and run your hands up and down somebody's back, because you're sending the wrong message, not because it's necessarily going to, you know, land you in court. So I don't think that people should stop hugging. I think that people, or touching, you know, shaking hands or touching on the arm. But if a person is uncomfortable with it, then I think you should stop. And if you sense that the person is uncomfortable, you should stop. And if you haven't stopped and the person reports you for harassment, the consequence of it is that somebody is going to say to you, you know, Jane doesn't like it when you hug her. Would you please not do that? I mean, that's the end.
Right, just respecting that person's physical boundary, which you hope would be common sense in a spiritual community. Great. Should we go back to the PowerPoint? Thanks very much.
All right. So here's the 3 steps. And your questions are fabulous. So I thank you for all of that, because they're illuminating the issues that you have that are, you know, that are special to the situations that you're in and not to the workplace. So I appreciate that. 3 steps, they're pretty simple. You have to have a policy. Now, a lot of people that I've been involved with and have said, well, but we have a policy. Well, that's fine. But sometimes the policy is not sufficient in what it covers. And sometimes it is, it doesn't give a process for being able to do what needs to be done. So we're going to talk about that. I'm going to give you some more, you know, kind of a deeper dive into policies. First, you have a policy, but that's the easy part. That is not the hard part. The hard part is enforcing the policy. So you have to, if you are not enforcing the policy, then it's of no good in protecting you from legal liability, number one. And number two, no one's going to use it. So that the only way that you can deal with legal liability on these issues is for people to use this policy and for you to enforce it. And by you, I'm talking about those people in a decision-making position on your board. So what does that mean? It means that you have a process, for reporting issues and concerns. And I'll talk a little bit more about that. And then you investigate to find out what happened and what are the facts. That is hard to do. And then after you've done that, then you take prompt effective action, which is designed to end any conduct that violates the policy or the law. Prompt effective action. And to the question before about reparative justice or restorative justice, then this is a place where this might come in. And it's at this point. But let's look at, for example, the policies, enforcing the policies and action. So what should a policy say? Well, first of all, it should say who it applies to. So if, for example, if it doesn't apply to the teachers or the teacher, and then it is not worth the paper that it's written on, just plain and simple. It has to apply to everyone in the organization. And in fact, a teacher and senior leaders should be held to a higher standard than students. So you have to think about the policy as being like the law of your organization. It's like your local law. If you think of it as like a triangle, it's at the top. At the bottom, we might have federal law. You can't go below that. So you can't say, well, in our organization, sexual abuse is okay. We're not following federal law. That's not going to work. You can be above that, though. You have to follow state law, but your law can be above that. And a great example of that is this. I don't know how many of you are aware of this, but for example, discrimination and harassment in the United States based on gender diversity or sexual orientation or any of that is not the law in a great many states. It is not protected as a federal law in the United States, and there are many states where that is not the law. However, I have yet to encounter a major organization that did not cover that in their policy, because their policy sits as their own law at the top, and they're able to say, you know what, we're not going to allow this, and you're able to do that as long as you're above the law, above the federal law and state law. So the policy should apply to everyone. You should be pointing out what are violations of the policy. And if you Google examples of workplace harassment policies, you will see dozens of them. And you can look at them and you will see that they're very, very similar. And you can kind of pick the things that make sense to you for your organization. One of the things that I really recommend that be in there, though, is consensual relationships. So where consent is possible, then you want to have something about consensual relationships. So the most common ones that I've seen, if you Google harassment policies, for example, in universities, you will often see a consensual relationship policy. They say things like this. They say, we discourage consensual relationships, but if you are in a position of power over a person who's beneath you somehow on the pecking order, then you must disclose that to us so that we can make any adjustments that need to be made. So you can kind of form and mold that concept to require disclosure. A lot of people will say in their policies that consensual relationships are okay in certain situations. You must disclose them. And if it's a situation where it cannot be mitigated, the power differential, then we don't permit it. So those are the kinds of things that are possible for you in consensual relationships. The next one is a big one. What is the process for reporting a violation of the policy? And I think this is the one, if there was one thing that you should go back and look at, it's this. Because a lot of people have a policy, but the process is not one that people trust. And why is that? Often it's because it goes to the leaders of the organization, and people may not want the leaders to know about this immediately, or they may want to be anonymous or confidential, or the leaders may be among those people who are violating the policy, in which case there is no place to go. So the law has long been clear that an effective reporting process has a number of avenues that people can go. If we were talking about a business organization, we would say you can notify your manager, you can notify another manager, you can notify the HR department, which of course you are not, having in your organization, so you can't have that. But you have to think about how you can have a process that people trust, and that reporting up to only to the leaders of the organization is not a process that's going to be robust enough to keep you out of difficulty. Confidentiality. So we've talked a little bit about that in the legal context. You should keep complaints as confidential as possible, but if it's a person who's complaining about another person, you are probably going to have to reveal that person's name in order for the person who's being accused to be able to defend themselves. So that is just something to keep in mind. Other than that, only a very small circle of people who need to know should be aware of it. Encouragement to report why you want this. A lot of business organizations don't have this, but I think that in spiritual organizations, it might make sense to reassure people about confidentiality as much as possible, to also be saying to people, this may not have been what our culture has been in the past, but this is what we're doing now. And so that might be something that you would want to include. We'd certainly want to have no retaliation clause in there. And to link, I was going to give you an example in the chat, and I didn't do that. So I'm going to give it to you in the follow-up. All right. So here's some of the suggestions. More than one way to report, more than one person to report to. Allow anonymous reports. You still have an obligation to investigate to the extent possible. But sometimes an anonymous person will then come forward if they feel that you're taking it seriously. The final one on this list, informal reports versus formal reports. There is no such thing as an informal report. So if someone comes to you and says, I'm just making an informal report, the way that I think about it is this: if you've heard it and you have some kind of power in the organization, then you're on notice. And what the law says is when you are on notice, you have an obligation to take prompt effective action. And so I see a whole lot of this, well, but the person didn't make a formal complaint, and there's no such thing as that under the law. You want to know what's happening. I know you don't really, any of us want to deal with this, but you have to, because if you don't pay attention, then bad things happen. And so this informal formal reports is not something that is useful. So here's just a very quick overview to help you think about the process of investigating. So the first question is it something I even need to investigate? And the answer to that is, if you take the allegation as true, would it violate your policy or the law? So if two people are having a personality conflict, it probably doesn't violate your policy. It certainly doesn't violate the law, and you don't have to investigate. You can, you can repair this, deal with this in whatever way that you would like. But for the purposes of what we're talking about, what we're saying is you should investigate any allegations of sexual misconduct, no matter what, because it's going to violate the law probably, and it should violate your policy. That's step one. Number two, who should do the investigation? Here's who shouldn't do the investigation. If it is the teacher, you should not do the investigation because no one will ever be happy with it. It will be perceived as being biased, and no one will trust the end result. And so if you saw in Shambhala, for example, they hired an outside law firm to come in and do the investigation. And even then, people didn't trust the results, but many people did. And so if it's down at the level of peer to peer, then I would recommend that you have someone in the organization that you feel is able to be neutral and objective, and who could be trained to do an investigation, because peer to peer does not have as much difficulty associated with it as it does leadership to student. What should I do before I jump in? Well, the first thing that I do, and I think always a good idea, is to say, what is the thing that I'm investigating? So if it's a low-level peer-to-peer thing where, let's say, someone has hugged someone and caused them to feel uncomfortable and feel that they inappropriately touched them, then the question is, what you should do before you jump in is to frame that in the form of a question, because it's very easy to get lost in an investigation. So you put forward a question for yourself if you're the investigator, and you say, did Bill inappropriately touch Jane when he hugged her the other night in the Sangha meeting? Then you know exactly what it is that you're trying to find out. Then you ask yourself, who should I talk to? Well, clearly you want to talk to Jane. You want to ask Jane questions like, was there anybody else around? Did anyone see this? Do you know of anyone else who's been uncomfortable if Bill has hugged people inappropriately? Then obviously you want to talk to Bill, and you want to talk to anyone else who may have knowledge. So you may say to Jane all of those questions about who else may know. And with Bill, it's very hard to prove a negative, but anything that he can contribute to why that wasn't the case. Or sometimes that people actually say, you know what, I think that I just, I was feeling super friendly and I won't do it again. That could be the end of it. The next step is, what other things should I look at? I'm sure I don't need to tell you that people lie and documents rarely do. So I try to look at documents as much as possible. Obviously, you want to talk with people, you want to get their information, and you want to find out from them who else might know things about it. But I always am asking for emails, texts, video chats. We have a long non-private trail of communications that can be mined in investigations. And then how do I come to a conclusion? Well, the standard that you're going to use in these things is called more likely than not. It's not criminal, which is beyond a reasonable doubt. It is more likely than not, which is that you have to put things on a scale and say, am I at 51% or higher? And that's how you come to a conclusion. At the end of that, you must take prompt effective action. So you've been on notice, you've been through a process, and now you're going to take action. There are many ways to take action. So this isn't like if Bill did get a little too, he was too enthusiastically friendly with Jane and she was uncomfortable. It's not like, a criminal offense. It's not even a civil offense, probably. It's just like saying to Bill, okay, a little awareness here of how you may be being perceived by other people. And then you want to make a note about it. And then you probably want to keep your eyes and ears open to make sure that Bill has really gotten the lesson. But really, literally, that's all it needs to be. However, the higher you go up into the organization, the consequences become different. And so then you may be looking at what I think of as paths to redemption. Is there a path to redemption for this person, or do they need to be let go? So that's where we are with the model. So, Anne, I'm back.
Great. There's some really good questions. And again, there's a lot of questions clustered around liability. So I'll work through
Yes.
them. So there's some general ones and more specific,
Okay.
so I'll try and do them in a good order. So first of all, what, if any, liability does a board have if a board member is aware of sexual misconduct but does nothing?
Yeah. Really excellent question. It's a hard situation to put in front of a jury. So, for example, just to give you a comparable situation, in a corporation, the law is extremely clear that any manager, so if, let's take, I don't know who, let's take IBM. I always think of them. I don't know why. They must have, a gazillion managers. Let's take Walmart. They have like 150 million employees or something like that. They have a lot of managers. Any manager who knows about sexual abuse, sexual assault, sexual harassment puts the organization on notice. So that's what a plaintiff's lawyer is going to be saying, that when that board member knew, that knowledge can be imputed to all members of the board. So it's a great question because it speaks to other actions that you need to take, which is to train your board to make sure that that person who knows that they have an obligation to report it to the board.
Great. So if an organization has a policy but does not respect it, follow it, I'm guessing, are they liable?
Sure. Absolutely. Short answer, yes.
So here's a more specific one regarding Shambhala. Shambhala's new care and conduct policy does not have an enforcement mechanism. How vulnerable does it leave them to legal liability?
Oh, yes. Big time. Yes. Yes. Right. Yeah, I'm glad. These questions are so encouraging to me because it means that you're getting the picture here. Yes, they have to have an enforcement mechanism. I actually think that there's something hidden. I at one time looked at this. I think there's something hidden deep inside, but they do not have a specific sexual abuse, misconduct mechanism for reporting.
Mm.
At least not that I was able to find. And so if they do not, and even if it's not readily available to the person who wants to make a report, it's a problem.
Great. So what, if any, liability does a board have if a survivor alleges rape, but it is not reported to the police?
Doesn't matter. The police, yes, the survivor has the option of reporting it to the police, but does not have to. And so if you think back to when we talked about criminal versus civil lawsuits,
right?
Civil rape is a civil lawsuit. And so the police do not necessarily have to have been involved.
Mm-hmm. Great. So this is one. Our Sangha has members who are lawyers, and based on their recommendation, we've started to carry a board insurance. Yeah. Is that something you would recommend? What must be included?
Well, so I don't know enough about the insurance issue to know what should be included in the insurance, but I can tell you this, that a lot of very wise people will not serve on a board that does not have D&O insurance. And for exactly the reasons that we are talking about, which is that liability is individual liability, and that means you. And so in the case that I've talked about before in California, the board has D&O insurance. The insurance provides their attorney. And as you all can probably imagine, the attorney's fees are astronomical, or they can be.
Great. Another Shambhala question. Shambhala leadership knew about MIPAM's behavior. How liable is the board of directors, and how would that be brought to a civil suit?
Yeah, such an interesting but complicated question. So let me try to make it as simple as possible. What is required is a person who was harmed within a statute of limitations, which is the time period in which you have to bring these lawsuits within a particular jurisdiction. So you can't say I was, in the United States, for example, you can't say I was harmed in New York, but I would rather have the lawsuit in California. There might be some circumstances in which you would be able to do that, but not generally. So it's not just a question of their liability, because my own opinion about their liability is, yes, they are liable. The difficulty becomes a complaining party who was harmed within the time frame of the statute of limitations. But note here, Canada has no statute of limitations in Nova Scotia anymore. And then a jurisdiction that will take the claim, which might be Nova Scotia. So we have so that there are a number of hurdles to get over before there can be that kind of lawsuit, but it's not impossible.
Great. Do you want to carry on and then take?
I will. I just want to do I want to do a little hypothetical example here so that we can kind of put this into practice. So I'm going to ask you this question. You're just going to think about it and, say the answer to yourself. But if you don't understand it, definitely type in. So here we go. In 2014, so this is an interesting question. Example, what we had a question about just before. In 2014, a woman tells members of a Sangha that the teacher touched her inappropriately. One of the people that she told later becomes a member of the board for this community. So the question that I have up here is the board on notice? Because being on notice triggers your obligation to take some kind of action. So think about it. She tells a woman not on the board at that time, but then later that person goes on the board. Is the board on notice? What I would say is that's really going to be an answer for a jury, because the jury is going to decide something like that. But what I'm going to tell you is you don't want to get to a jury in order to find the answer to that question. You want to assume that all of your board members are on notice when that happens, because you want to take prompt, effective action. That is your way of doing the right thing for your community, but also doing the right thing from a legal point of view. All right, so now, this is so small, I have to put my glasses on. I'll read it to you. 4 or 5 years later, a community member comes to the board. Now here you should be thinking, this may be putting them on notice, if it didn't before, to say that she knows of a woman who said she was inappropriately touched by the same teacher, but the woman wishes to remain anonymous. So the question is, does the board need to do anything? And the answer is yes. Even though the woman may wish to remain anonymous, the board has an obligation to investigate to the fullest extent possible. And I would add that if you have a track record of having a robust process and a track record of looking into these things. That process will be trusted, and you can deal with the anonymous issue. There's always a way to deal with the anonymous issue, but the answer is yes, you need to investigate. You need to talk to this third party. Now, there are a couple of tricks here that people may be, fooled by. That is, well, the woman herself didn't come to the board. The law doesn't care. The law doesn't care who comes to the board. It's just about, do you know it? Once you know it, you have to do something. We don't care about this other stuff. If it's credible, you need to look into it. So we don't care about that. And then we also need to work with the anonymity issue. So we can't just turn our backs and say, I can't do anything about it. All right, next step in my hypothetical is the board approaches the teacher because their policy says that they do need to do an investigation. So they approach the teacher and they give the teacher the information that about and this was interestingly enough, started with a hug. It was an enhanced hug, I would say. And they gave the teacher that information. The teacher said he knew who it was. He could guess who it was, and that student was needy and crazy. So can the board walk away now and rest in peace? So I hope that you are saying, no, they can't. Because just because they feel, and this is the last part of it, that they have heard the whole story and that they can't do anything anyway because the woman wishes to remain anonymous. And besides, they are only doing this as volunteers in order to be close to the teacher in the first place. We didn't sign up for all of this chaos. Never mind. Good strategy? No. Because that's what the meaning of enforcing the policy is, that in every situation, you go as far as you can. So in this situation, if they had gone as far as they could with the anonymous issue and they couldn't get any further, it would at least have provided first of all, the knowledge to the community, well, they wouldn't know about it this time, but their ability to say, we look into every single one of these things, which you should be able to say. And secondly, that it would be somewhat of a protection if they get sued on this, that they tried, but they didn't do that. So no, not a good strategy. Further, I thought this was the last one, but no. Between the time that the board heard the whole story, now notice no investigation can really be called the whole story by simply talking to the teacher, but I have run into a couple of situations where that has been the case. So they heard the whole story from the teacher, and when an outside investigation determined that the teacher had indeed inappropriately touched other women, yet another woman said that she was sexually assaulted by the teacher in between the times. In other words, this is harm that was done that could have been prevented. And so hopefully that reminds you of the definition of negligence, which is failing to do something which causes another person predictable harm. And that's the example here. So, questions. All right, so I think, Anne, that we have 15 minutes for questions.
Yeah, that's super. It's worked out great.
I'm going to put up the, I want to just say that I want to put up the survivor mailbox, and I don't know if it's in the chat box. If it's not, it's here.
Yeah, we did. We put in several times, but
thank you.
Yeah.
So for any of you who are out there who either are or know of people who are dealing with these issues within their communities, this is a confidential mailbox.
Thank you. So follow up, this is the next question. Following up on hugs, is there any legal protection against all the behavior that is associated with grooming that usually precedes outright abuse?
Mm-hmm. Interesting. That is an interesting question. And unless it falls, so here's what a couple of things that I would say. Unless it falls under harassment. So, but grooming is usually psychological, I think. And so I think that the answer there is, unfortunately, I don't know of any legal protection there. But what I would say is, this is another one of those things that, as those of you who are going to go back and say to your leadership or to the boards that you are on, we need to be more alert to some of these issues, and here are some of the things that we can do. I certainly think that there are lots and lots of folks who are doing training on grooming and some of these issues. So being alert to that, so that when you see it, you recognize it for what it is about the only thing that I can offer right now.
Thank you. So can you speak more about how we can work on prevention?
Mm-hmm. Well, yes. So grooming, having some kind of training. I really think that if you go back to your Sangha and you redo your policy, then it's a perfect opportunity to have some community meetings and tell people what it is that you're doing, what it is that you're not preventing, rolling out your robust process of taking in complaints, and educating the community to what they should be alert to also, because I think that says a signal that we're interested in this. We're going to do this in the right way.
Great. So a technical one is, can organizations that are based in the US be liable for what happens in their branches in other non-US places?
It is possible. Yes, it is possible. So, so a real full answer to this would require more knowledge of class actions than what I have. But I will tell you as an example that sometimes if an organization has a headquarters somewhere, they may have some liability for things that happen in other locations where they are doing business. But this is a very complicated jurisdictional issue. And I'm sorry that I don't know more about it.
Thank you. You'd mentioned the path to redemption.
Yes.
What does this mean given the low rate of therapeutic success in treating sexual predators?
Right. Yes, that I'm very happy for that question, because I don't really mean it for that. I don't really think that it's available for that. So I'm glad that someone caught that and is giving me the opportunity to clarify. I think where people have had what we might think of as a consensual relationship, but in which there has been a power differential, and the person has taken responsibility for what they've done and has shown some willingness to address the issues that caused them to be in that position to begin with. I think there's a path of redemption there, or restorative justice, that kind of thing. But yes, no, I think that it is the case that I would not say that a person who has committed criminal behavior, whether or not there is a criminal charge, I don't see a path to redemption there.
Thank you. So how do you keep an offender from going from one community to a new community when they've been, kind of exposed and maybe disciplined in one community, but they just go off, and start another one, either in the US or Europe?
Very, very little remedy for that. unfortunately. And it goes back to the question where someone asked about having the kind of big umbrella Buddhist organization that would kind of be a place where you could, look to see if a teacher was, on some kind of suspension. There are organizations in other Buddhist communities other than the Tibetan ones that have the SZBA, for example, does this kind of thing. So you should be checking to see whether a teacher is active and, in good standing, so to speak. But where there is not that kind of umbrella organization, it is very hard to keep people from going to another Sangha.
Great. So there's a couple of questions that are really pointing to difficulties around narratives of, in a community, behavior is not seen as abuse, it's seen as consensual. But outside of the community, it would be seen as non-consensual. So what if abuse happens inside what the organization defines as consensual, but others would see it as abuse?
Well, if others
so a similar question like that about,
if others would see it as abuse, then I guess I'm wondering whether it would, as a, going back to our definitions, whether we would say that it was sexual misconduct. And if we would, then it doesn't, again, it's like the triangle, the pyramid. Your law may be at the top, but it can't say, well, in our community, rape is okay as long as it's among adults.
Right.
You can't. So I may not be understanding that. So if the person who wrote that will put it in with more specificity about the behavior itself, then we can answer it in the follow-up.
Great. So this is one that kind of mixes, I guess, a religious narrative with, with a legal narrative, but it's how can we assess when a disciple's allegation of sexual misconduct by a teacher is a matter of clearing up misperceptions versus teacher conduct requiring action?
Yeah, by doing an investigation. That's the link right there. That's the connecting the dots, because we don't know. The reality is that I can say this absolutely, that every single survivor that I have worked with, which has been quite a few in the last 3.5 years, has been grateful for an investigation, to be able to be listened to and to be able to put their credibility and the evidence that they have out there for people to see. So that's what needs to be done. There needs to be an investigation, because otherwise you are never going to know.
So this is one about training. A member says, our senior teachers have had special clergy training. Do all ordained as monastics need to have this training, or novices, postulants? Would you recommend a clergy training in a wide range, I think is the question.
Yes, absolutely. I think that training is like, taking an aspirin when you start to get a headache, instead of letting it rage, for a day and a half and then have to go to bed with it. That's training people what is expected of them. And look, we have people from different cultures who are coming here as teachers. We need to give them information so that they don't make these mistakes.
Great. I think this is a good question to perhaps to end on. What is the community's responsibility to help the person who is abused kind of recover and heal? What's a larger responsibility to the survivor?
To me, I think that the community does have that responsibility. I don't think that is a, kind of a legal issue, but I think that it is an issue that communities, some communities, when this has happened, have taken a very proactive approach to trying to support the survivor and to help the survivor heal. And I think that that's, for me, and then again, this is just my personal opinion, I believe that it is the responsibility of the community to do that.
Super. Well, we've just got a few more minutes left. I wondered if you might, is there anything that you want to kind of share with us at the end, perhaps more of a general kind of reflection on, you know, you've been working in Buddhist communities now for several years. I know you've gone through a kind of trajectory, and, you know, where are you feeling about the current landscape of where Buddhist communities are at with this issue?
Yeah, great question, Anne. Thank you. Well, so what I see is that there is a great deal more awareness, you know, so we're seeing more, you know, we're seeing a lawsuit against the Karmapa, for example, and, you know, whatever happens with that, it brings up to the front of people's minds that this is still going on, and it is still going on. Some really unconscionable things are being done in the name of Buddhism and spirituality. And so what I see is that I see that there are more women who are willing to come forward under the right circumstances, and that my goal is to try to help, like, this group of people that's here today, these people who listen to this, who are obviously wanting to do the right thing, to be able to do it. So we can't just keep, you know, after the fact, having people harmed and trying to bring that to light and bring it through the legal system. You do that, it'll be done as it needs to be done, but the real work has to be within each and every spiritual community. So that's kind of where I'm focusing my practice, which is, as I said in the beginning, why I'm here today. But one thing that I would really like to say to people, that beyond the narrow confines of their own communities, is that when you see that a teacher, maybe a teacher that you know, maybe a teacher whom a lot of people know, when you see that someone has been accused of this, that you wait for an investigation to be done before you take sides. Because I think that what I have seen that has been the most discouraging has been other teachers saying that can't be true. This is a woman scorned. That's an old, that went out with Shakespeare. You know, our inability of our teachers to understand that this happens is really something that we should be working on as a big, larger community. And within that big, larger community, what we should be saying is, let's encourage an investigation. You mentioned the Noah Levine thing. Very, very helpful to have had 2 investigations there. Do not take sides until somebody has put their hands on the interviews, the documents, and all of the evidence. And then when somebody says, yes, this happened, that you support the survivor and not the teacher who was your friend, who you took refuge with, or whatever it may be, because it's going to take the wider community for us to make a dent in what's happening without the kind of umbrella organization that someone mentioned in the beginning.
Thank you, Carol. I'm just going to bring Amy up. I think I really love that you ended on those words, you know, to support survivors, to believe survivors, and to believe survivors. It was really, I think, an excellent place to end. And we are incredibly grateful for the time that you are spending on working towards preventative training, as well as working on responding to great harms that have been done. We admire and respect you so much, right, Amy?
Absolutely. Thank you so much, Carol. That was tremendously helpful.
Thank you.
So yeah, it's time to end. Thank you everyone for attending. We will send the recording to everyone who registered, and we really encourage you to share it with other Sangha members and teachers, to really kind of get this knowledge out as wide as possible, which I think you'll agree is a really invaluable knowledge. Okay, so thanks Carol, and thanks everyone. Have a great rest of your day. Thanks for your time and attention.
Thank you.
Bye.